Good morning, good afternoon, and good evening, everyone. Now, before we begin, let's do a quick technical check to make sure everything is running smoothly. Can you all hear me clearly?
Yes.
Thank you. Excellent. If you can also see me on video without any issues, please give me a quick thumbs up or a note in the chat, please. Okay, perfect. That seems to be working. Everything seems to be in order, so let us begin. Good morning, good afternoon, and good evening, everyone. Thank you for joining us. My name is Byung Ko, and I am a 2L student at Yonsei Law School, and I am the current president of Yonsei International Arbitration Association. It's an honor to host such an amazing event as a student studying law in South Korea, and on behalf of our association, I extend a warm welcome to all of you at the 2025 Yonsei Arbitration Day. The YAD is an event that we are all proud of. It holds quite a special place in our hearts. The YAD is unique in that it is Asia's first pioneering student-organized annual arbitration conference. This is the sixth annual YAD, and we aim to establish a platform for distinguished scholars, practitioners, and students worldwide to learn, communicate, and expand their thoughts. Our long-term goal is to ignite inspiration that can influence the field's future trajectory. Now, this year's YAD features two panel discussions. As you have all seen in our flyer, we have assembled leading experts from all across the globe for each topic. First, we will delve into the arbitration in the space sector, exploring how commercial and sovereign interests intersect beyond Earth, shaping the future landscape of dispute resolution. The second session is called Tips for Young Practitioners, Foundations and Pathways in International Arbitration. I hope the audience will be able to gain invaluable advice from the best professionals in the field. Before we begin, a heartfelt thank you is to our esteemed institutional partners, Korean Commercial Arbitration Board International, Hong Kong International Arbitration Center, and Singapore International Arbitration Center. Their support has truly made this event possible. Now, to begin, it is my distinct pleasure to introduce Ms. Pui-Ki Emmanuelle Ta, Secretary General at the KCAB International, for the opening remarks. She needs no introduction, but to be brief, she has over 20 years of experience in international arbitration, including senior leadership roles at the ICC in Paris and Hong Kong, and later as CEO and Secretary General of EBROM International Online Dispute Resolution Center. Today, she leads KCAB International with distinction, advancing its role as a premier institution in global dispute resolution. As I extend our gratitude for her contribution to this event, please join me in welcoming Ms. Ta to the stage.
Thank you very much for a very kind introduction. Distinguished panelists, students, practitioners, and academics, it's a pleasure to welcome you to Yonsei Arbitration Day. I'm honored to speak today on behalf of KCAB International, Korea's leading institution for international dispute resolution, and proud to support this event in collaboration with Yonsei University Law School. Today, we will dive into two exciting and timely topics with the help of our distinguished panelists: arbitration in the space sector and tips for young practitioners, foundations and pathway in international arbitration. As the new space economy continues to expand and space activities become more complex, it is inevitable that disputes will arise. These may involve high-stakes disputes between government agencies, private companies, investors, research institutions, and international organizations. Others may arise between space service providers and end users who rely on satellite services, telecommunications, and other space-based technologies. Given the diverse ecosystem of the space economy and the involvement of various stakeholders, the dispute resolution community is increasingly recognizing the need for establishing effective mechanisms to manage these conflicts. This is reflected in the publication of specialized arbitration rules by some arbitral institutions tailored specifically to address space-related disputes. Arbitration will play a key role in shaping how we manage risk, responsibility, and cooperation beyond Earth's borders. At KCAB International, we've been exploring similar themes in preparation for our upcoming Seoul ADR Festival, SAF, where we aim to further examine the legal challenges and opportunities in outer space. Equally important is this conversation around how young professionals can build meaningful careers in international arbitration. And at KCAB International, we are committed to supporting the next generation of arbitrators and practitioners. To those stepping into the world of international arbitration, I'd like to offer a few thoughts and encourage you to engage with the arbitration community, attend events, ask questions, and contribute to the dialogue. And stay open to new sectors, from construction to tech to space. Arbitration touches every industry. International arbitration is a truly global community, and by being here today, you are already part of it. Now, let me share some updates and recent developments at KCAB International and how we are continuing to strengthen our presence in the global arbitration landscape. As many of you know, KCAB International is a globally recognized and independent arbitration institution with experience in handling international arbitration cases. Under the leadership of Professor Sung-Hwa Chang, chairman of KCAB International, the institution has undergone a strategic refresh, one that advances international arbitration in Korea and beyond. We've been working to modernize KCAB International arbitration rules since 2023, and to lead this important initiative, KCAB International formed a rules committee chaired by Professor Jung-Gi Kim. The committee has been working closely with the Secretariat of KCAB International to propose amendments to the 2016 International Arbitration Rules, and I'm pleased to share that we are now in the final stages of this revision process. KCAB International has also launched several new initiatives, including the translation of Korean arbitration-related court decisions into English, and setting up a platform to make the English version of these court decisions available and accessible to the international community. We believe that this is an important step toward greater transparency and building confidence in Korea as a seat of arbitration. And we hope to be able to launch this platform by the end of this year or early next year. We're also proud to introduce the International Arbitrator Training Program designed to support and equip the next generation of international arbitrators in Korea. And later this week, KCAB International will be hosting the first edition of the International Arbitrator Training Program, and we will be welcoming 31 participants coming from 6 different jurisdictions. KCAB International will also be hosting the Seoul ADR Festival from 27th to the 31st of October. And this year's program will feature a wide range of events, discussions, and networking opportunities, with KCAB International hosting 3 main events: the welcome reception on the Monday of that week, followed by the inaugural Asia Civil Law Summit on the Tuesday, and the flagship event, the ADR Conference, on Wednesday. And we warmly welcome you to take part of the 2025 SAF. So once again, and on behalf of KCAB International, thank you for being with us today. We look forward to the insights that will be shared and to the continued advancement of arbitration in Korea and beyond. I wish you all a productive and inspiring day, and look forward to seeing many of you in Seoul for Seoul ADR Festival. Thank you very much.
Thank you, Ms. Ta, for your kind and inspirational words. We believe that your insights will greatly enhance our understanding and guide us in navigating the world of international arbitration. Now, let's kick off our first session. Before we jump into the discussions, please note that a Q&A button is available on your screens. We encourage attendees to share their questions, which our moderators will consider during the panel discussions. Now, I would like to begin by introducing our moderator for session 1, Ms. Eun Lee. She is a proud alumna of Yonsei Law School, currently an associate at Pui-Ki Lee. Please welcome Ms. Lee to the stage.
Thank you, panel, for your kind introduction. It is a great honor to serve as the moderator for the 2025 YAD, and I'm truly delighted to welcome all of you to our first session entitled Arbitration in the Space Sector, the Next Frontier for International Disputes. This session explores a field that is both fascinating and rapidly evolving. As commercial activity in outer space expands from satellite deployment to space tourism and beyond, so too does the potential for legal conflicts crossing borders and industries. Arbitration, with its flexibility and international character, is poised to play a vital role in resolving these unprecedented disputes. We are fortunate today to be joined by three distinguished speakers who bring a wealth of experience and insight from both academia and practice. They will guide us in exploring how arbitration can adapt to the unique challenges of the space sector and highlight the opportunities that lie ahead for practitioners in this emerging field. Our first panelist is Professor Yun Zhao, Henry Chang Professor in International Law and Associate Dean at the Faculty of Law, University of Hong Kong. Professor Zhao also serves as the representative of the Hague Conference on Private International Law's Regional Office for Asia and the Pacific, and is a director of the International Institute of Space Law. He's currently listed as arbitrator with several leading international arbitration institutions, and is also vice president of the Hong Kong Institute of Arbitrators. Over the years, Professor Zhao has been widely recognized for his scholarship and publications on dispute resolution and space law. Our next panelist is Ms. Laura Yvonne Zielinski, a specialist in international arbitration with a strong focus on investor-state disputes, public international law, and space law. Until recently, she served as senior counsel at Holland & Knight in Mexico City. Also, what makes her perfectly well-suited for today's session is that in 2021, she founded the Space Arbitration Association, where she continues to serve as president. She's also a member of the International Institute of Space Law and vice chair of the Space Law Committee of the International Bar Association. Drawing on this experience, she will provide us with an overview of today's space industry and offer insights into past and potential investment claims in the space sector. Our final panelist is Ms. Julia Dreosti, partner at Clifford Chance in Australia. She advises clients both domestically and internationally on dispute avoidance, contract administration, and risk minimization throughout the project life cycle, with a particular focus on the aerospace and defense sector. Ms. Dreosti has extensive experience across all forms of dispute resolution, including international and domestic arbitration, litigation, expert determination, and mediation. Her practice has spanned Asia and Europe, giving her a truly global perspective. Today, she will share her insights on multi-tiered dispute resolution clauses, examining the pros and cons in the context of space-related agreements. We are deeply grateful to our three panelists for sharing their valuable time with us today. So without further ado, I now invite our first panelist, Professor Zhao, to take the floor.
Thank you, Chair. Thank you very much for your very kind introduction. Ladies and gentlemen, good morning, everyone. I'm very pleased to have the opportunity to give a short presentation on the space commercialization and dispute resolution. Space law is, as you have known, I think is one of the very promising areas, and space has been considered to be the final frontier. With the launch of the first man-made satellite in 1957, we can see a lot of countries are joining the space club, and a lot of space activities taking place since then. Shortly after the launch of the first man-made satellite, the United Nations was very quick to respond in issuing several very important UNGA resolutions, and also more importantly, 5 space treaties were enacted. Namely the 1967 Outer Space Treaty, the 1968 Rescue Agreement, 1972 Liability Convention, 1975 Registration Convention, and 1979 the Moon Agreement. All these space treaties were enacted during the space 1960s or 1970s when there are only 2 superpowers. But starting from 1980s, we can see a lot of changes in space activities. More and more participants joining the space club, and we can see increasing private capital investment in the field. More importantly, we're looking to something new activities such as the exploitation of space resources, and also, of course, the telecommunication services and remote sensing services, etc. So this brought in quite some new legal issues because the 5 existing space treaties were drafted during the Cold War period with the state as only space actor. But after the space commercialization and privatization, we can see more and more private entities are interested or are involved in space activities. So whether the current space legal regime is sufficient to deal with the new issues that are coming up from space commercialization and privatization. So a lot of discussion has coming up. But if we simply look into the commercial activities in outer space field, I would say the most 2 successful areas in the space law areas is the telecommunications and remote sensing. But more and more activities are coming up, including the launching activity, transportation, including space tourism, communication, and navigation, etc. With all these space commercial activities in place, disputes will inevitably come up. So if we talk about space disputes, we will mainly refer such disputes as disputes having an outer space component involving the use of outer space by states, international organizations, and private entities. For a long time, when we talk about dispute resolution, we will refer to 4 basic dispute resolution mechanisms, including negotiation, mediation, arbitration, and litigation. Of course, apart from these 4 basic dispute resolution mechanisms, we can also see other alternative dispute resolution mechanisms, including, for example, meet-up, fact-finding, expert determination, etc. But now, if we specifically look into the space field, I would specifically pick up 4 major documents or 4 major mechanisms that have come up since 1970s. The first major document, I would say that's the 1972 Liability Convention, to be followed by the 1998 International Law Association's Draft Convention on the Settlement of Disputes Related to Space Activities, which I think is a very comprehensive document, but unfortunately it has never come into practice, or we do not have enough signatories for this convention to take effect. That's the second. The third very important document is adopted in 2012 by Permanent Court of Arbitration, PCA. The PCA issued in optional rules for arbitration of disputes relating to outer space activities in 2012. And then, of course, there's also the latest development in 2021 by the Dubai International Financial Center Court of Space. So I mainly focus on the discussion of these 4 major documents. First, the 1972 Liability Convention indeed includes several very important mechanisms. First, if there are disputes, then we will try to resolve the disputes through diplomatic negotiations. If the negotiation fails, then of course you can continue for further procedures. There's no requirement of the prior exhaustion of any local remedies. Moreover, if there's no settlement within 1 year from the notification of the claims, then the 2 parties can consider to set up a claims commission at the request of either party. This has been considered to be one very important mechanism, claims commission. If we look into the functioning of the claims commission, it's quite similar. Similar to the arbitration mechanisms. But unfortunately, this convention has not been practiced. I wouldn't say no disputes at the moment has directly used the mechanisms in liability convention. Although some scholars would argue that when the former Soviet Union satellite fell down in the Canadian territory, actually the negotiations between the former Soviet Union and Canada can be considered as the diplomatic negotiations that were put down in the liability convention. But anyhow, I think this liability convention only applies to the dispute resolution between the states. It does not really directly refer to the disputes between the commercial and private entities. Then we move to the International Law Association's draft convention in 1998. This is one very important convention. I would say that that came up in the 1990s. During 1990s, we can see that quite a lot of specific or specialized tribunals were set up at that time. For example, apart from the International Court of Justice, we can see the specific or specialized tribunals were set up for the disputes related to the law of sea. There are also discussions about the international criminal tribunals for former Yugoslavia and Rwanda, etc. But is exactly during that period of time, there were also discussions about the tribunals for the disputes related to environmental disputes and also tribunals for space disputes. So we can see that there are quite a lot of important background also information regarding why at the time the International Law Association started to talk about the draft conventions for the dispute resolution for space disputes. But anyhow, I think that this ILA's draft convention did not take effect. It's very comprehensive, but we can see it's still controversial, or different scholars and practitioners hold different views regarding the effectiveness of this convention. Anyhow, we can see the draft convention applies to all activities in or with effects in outer space. It includes two categories of dispute resolution procedures. The first category is the non-binding procedures. The disputing parties can exchange views through negotiation or conciliation, mediation. So that is a starting point, to be followed by binding procedures, including arbitration, Space Law Tribunal, and International Court of Justice. So arbitration has been put on in a very important way, or there's specific chapters dealing with the arbitration for space disputes. And then, of course, it touched upon the possibility of setting up the special tribunal for space disputes. So that is a major development in the 1990s, although it did not take effect. Now then we move to the third document, which proves to be very important and very meaningful development. That's PCA Optional Arbitration Rules, which was adopted in 2011 and took effect in 2012. These optional arbitration rules are based on the UNCITRAL, the United Nations Commission on International Trade Law Arbitration Rules. According to the rules, there's a waiver of state sovereignty in the procedures. There are some very important reforms or new mechanisms which were introduced to the arbitration of space disputes. For example, it put in the confidentiality advisor. This means if the two parties were very concerned about disclosing some space secrets or some technical aspects to the arbitral tribunal, they can disclose to the confidentiality advisor. The confidentiality advisor will be in a position to draft or to formulate or draft the statement in a neutral manner, which will be helpful for the, keeping the confidentiality of space disputes or technical aspects of certain disputes. So that's, I think is one very important aspect regarding the highly confidential element or nature of the space disputes. Moreover, it has been defined that the arbitration procedure is voluntary in nature, and the whole mechanism fully respects the free wills of the parties. So far, the PCA optional arbitration rules has not been practiced or has not been adopted by the two parties in real cases. There were quite some discussions regarding possible problem why the optional arbitration rules have not been used in practice. It has been considered to be very good and very useful arbitration rules, but why no parties have used that? I think that the one major reason is that probably there were no sufficient promotional campaigns for optional arbitration rules. I think this has been considered to be one major reason. So that means I think probably we will need to have more promotion campaigns to promote the optional arbitration rules so that more parties will know about this type of rules. But anyhow, I think there are also some other arbitration rules by different arbitration institutions regarding the use of arbitration for space disputes. I myself was also arbitrator. So far, I've received or dealt with 3 arbitration cases. All these cases did not really use optional arbitration rules. They use, for example, they simply use unsexual arbitration rules or some specific institutional arbitration rules. So in a way, we would say that normal or general arbitration rules can still be used to resolve space disputes. But the PCA optional arbitration rules have included several very important features which can fit in this type of disputes, space disputes. So that's why I think it will be useful that we can do more work to promote this type of arbitration rules. So with these 3 very important mechanisms, I would like to come to the last very important development, that is the 2021 Dubai International Financial Center Courts, Space Courts. In 2021, the DRFC Courts and the Dubai Future Foundation started a new Courts of the Future initiative, activating Courts of Space. The purpose of the DRFC Space Courts includes 2 aspects. First, it set up an international working group to explore space-related legal innovations and provide an outlook on potential outcome of scenarios revolving around space-related disputes. So that's the first objective, to have a working group to study legal innovations in the space field and also potential results coming up from the space disputes. So that's the first. The second, the DRFC Space Courts would also like to create a space dispute guide, which can set up or include a set of guidelines to support space-related disputes with a parallel training of judge. So this has been considered to be 2 very important objectives of the DRFC Space Courts. DRFC Space Courts also have one very important aspect regarding how to resolve the disputes. It heavily rely on the online dispute resolution. So that means basically the whole proceedings can be conducted online. So ODR has been used to be the most appropriate mechanism to resolve space disputes by the DRFC Space Courts. This project is still in the starting stage. We will still need to keep a very close look at the future developments of the DRFC Space Courts. So with the discussions of these 4 examples or 4 very important projects regarding the dispute resolution of arbitrations for space disputes, let me summarize. First, space law were drafted during the Cold War period. The 5 existing space treaties were mainly targeting the state as the main actor, the target as the states as the main actor. So space commercialization and privatization brought in challenges. With more disputes coming up in the space fields, we will need to look into possible dispute resolution mechanisms for space disputes. Apart from space litigation, the court, we will also need to look into the ADR mechanisms, alternative dispute resolution mechanisms. So that means negotiation, mediation, and arbitration will play a more and more important role in resolving space disputes. But with a technological development, we will also need to look into the use of high technologies to facilitate the dispute resolution process, which will in the end lead to the adoption of ODR, including online arbitration, online mediation, online negotiation, and of course, we have the online court, the internet court. So with all these dispute resolution mechanisms in place, we believe that space disputes can be resolved in a more efficient and effective manner. So with this, I conclude my presentation. Thank you very much.
Thank you, Professor Zhao. It was really helpful in understanding the legal framework in this space sector. I have one question. As you have explained to us, we have seen new initiatives such as the establishment of specialized space arbitration court in Dubai and the drafting of clauses tailored for space disputes. In your view, how effective are these institutional developments in fostering the predictability and legitimacy? And beyond the need to promote such mechanisms, what do you think are the additional efforts that would be necessary for these new specialized space arbitration to become a mainstream option for stakeholders?
Thank you very much. Dispute resolution, I think, has been considered to be very important. I think for space disputes, basically, I think focus on the four mechanism. But we, of course, can also look into the EU side. EU, basically, they also have they have the sample agreements regarding using the arbitration. That if there's no special arrangement, then we specifically go to the ICC arbitration rules, and also the language to be used in English. So there are quite a lot of some developments. But I think, as you correctly pointed out, the DIFC is the space court. I think the one very interesting and very useful development. I believe that this DIFC at the current stage can set up the working group and also try to come up with a manual to providing the guideline for the dispute resolution mechanism. I think this has been very useful. But very important aspect is regarding the use of the technology for ODR. Online dispute resolution has been considered to be the most important development since late 1990s. We can see that in the mid-1990s, the United States has already started to experiment on the ODR. But unfortunately, the ODR did not succeed in the first 2 or 3 years. The experiments, the projects only survived for 2 or 3 years, then it died down, it closed down. So there were quite some studies regarding why the ODR platform did not work well and did not stay longer. This mechanism, I think, only become quite successful only after the introduction of the domain name dispute resolution mechanism. UDRP is a domain name dispute resolution in 1999. Afterwards, there were some discussions regarding how the domain name dispute resolution succeed and whether UDRP, the domain name dispute resolution, can extend to other type of disputes. My view is that the domain name dispute resolution mechanism can be used to domain name disputes, but probably it is not appropriate for other disputes involving complicated issues. So starting from the 2010, we can see a lot of international efforts were put in to discuss how to regulate the ODR. The first substantive achievement was made in 2016 by the UN UNCITRAL, United Nations Commission on International Trade Law, by the adoption of the technical notes on ODR in 2016. But still, many practitioners were not satisfied with the technical notes on ODR. So in 2019, the APEC, the Asia Pacific Economic Cooperation, were able to adopt another very important document regarding the collaborative framework and the procedural rules for ODR. So with all these as a basis, we can see that the Dubai DRFC Space Course started to think about the use of the ODR in 2021 for the resolution of space disputes. So in that aspect, I would say that ODR is good, is appropriate for the space disputes. But of course, we can still we should not disregard the use of traditional dispute resolution mechanism. So that is one aspect. Regarding what we can do and how to promote, I think for the optional arbitration rules I've just mentioned, this is very good rules. I still remember, I think a few years ago, probably in 2015 or 2016, I wrote an article regarding the optional arbitration rules for telecommunication disputes. Since there were some discussions, but not many, I think the point is that we do not really do a lot of work to promote these arbitration rules. So I think in the future, apart from the promotion of ODR mechanism for space disputes, but probably we can also do something more regarding the optional arbitration rules to use arbitration for space disputes. So I think probably this will be something we can look into. Apart from arbitration, of course, we can think about other ADR mechanisms. And also to think about what mechanism can be used to improve the arbitration mechanism to deal with the space disputes. For example, we have already known about the confidentiality advisor. We can see that the optional arbitration rules can provide flexibility of the number of arbitrators for the space disputes, etc. So I think these are all very good, but we can see the UNCITRAL also doing quite a lot regarding the arbitration dispute rules. For example, they introduce third-party funding, they introduce the fast-track arbitration rules, etc. I think all these we should study how to incorporate into the arbitration mechanism for space disputes. So I think I will stop here. Hopefully I've answered your questions. Thank you.
Thank you so much, Professor Zhao. It was really helpful. Actually, we have one more question from the audience. Moon Sushin has asked us one question. I'll just read it word by word. I also find it a bit paradoxical that some of these important major documents, which I assume were drafted with significant efforts, are not being directly utilized in resolving current real-life conflicts. Considering the lack of their real-life usage, what do you think is the real role of legal professionals in utilizing these traditional documents, especially in the era of AI, so that these important documents do not go outdated?
Thank you very much. I think this question also has something to do with ODR. First of all, I think I must say, I think when I have dealt with 3 arbitration cases specifically related to space. I think most of them are satellite or remote sensing disputes. Yes, they did not really refer to the 2012 optional arbitration rules. They do not really look into the 1972 liability convention, etc. They mainly refer to one UNCITRAL arbitration rules, the model laws, and also one case they used the specific institutional arbitration rules. So that is the cases I dealt with. But well, I must say that when I hold hearings, we do use the online hearing. So that means I did not really fly over to the physical space to hold hearing. So in a way, I think we can see that actually we have already used the kind of ODR to resolve the disputes that for one case. But more specifically, if we look into the AI, I must say ODR indeed has been trying to develop certain elements to facilitate the use of AI for the resolution of the disputes. For example, during the pandemic, we have been using the ODR to resolve the disputes. In the first place, we are thinking about ODR platform only can be used to resolve the disputes. But we found out that actually after the pandemic, quite a lot of cases still move back to the traditional dispute resolution mechanism instead of ODR. So there were quite some discussions. How can we promote the use of ODR? There were already some discussion regarding the access to digital justice. That means we would like to talk about the ODR in a broad manner or more general manner. That if we talk about the ODR platform, we are not only talking about the dispute resolution on the ODR platform. We look into 4 stages. First, the ODR platform can be used for the deal making. That means we can incorporate the smart contract, etc., to help the 2 parties to negotiate, to come to the conclusion of the contract. So that's a deal making. After the deal, the contract is concluded, then we move to the second stage. We use a blockchain, etc. All these elements can help to inform the 2 parties to carry out their duties. Now it's time for you to pay money. You will have to deliver the goods, etc. So try to avoid potential failure to carry out your duty. So that's the second stage. But even if there's some reminders and try to avoid disputes, there are always disputes. So we can move to the third stage to resolve the disputes. That's ODR. So during the dispute resolution procedures, of course, we use various mechanisms to help the 2 parties to come to the consensus or to make the arbitral tribunal, arbitral awards. Then that's the third stage. The last stage relates to the enforcement and of the arbitral awards or final decisions. So we can also have the digital currency, digital cash, to help to facilitate the implementation of the final decision. So that's the ways we can think about the ODR. It's not simply talking about the dispute resolution. We are talking about also dispute prevention and dispute resolution, I think, in 4 stages. So that all these 4 stages should involve the use of AI, smart contract, and blockchain, digital currency, etc. All have been involved. We can see different platform has been set up. Arbitration institutions have their own ODR platform. Furthermore, we also have specific companies which provides ODR services. For example, I think we have just mentioned about EBRAM is a specific company providing the ODR services. Also, we have e-commerce platform which also has the internal complaint system like the Alibaba, Baidu, etc. They also provide their own dispute resolution mechanism. So these are all very important mechanisms to use ODR. And for the dispute resolution for space disputes, I think that obviously we can use all these, the same concept or framework of ODR platform for the space disputes. So thank you very much.
Thank you once again, Professor Zhao. Your comments, not only on the traditional framework, but also on newly established dispute resolution mechanisms, particularly the use of ODR, has been very insightful. I believe they have been highly valuable and inspiring for all the practitioners here today. I think it's now time to move on to our next speaker, Ms. Zielinski. Yes, without further ado, Ms. Zielinski, the floor is yours.
Thank you very much. First of all, if I'm not as sharp as usual, I apologize. It's around 4 a.m. in France, so it's pretty late, but I'm very glad to be here. Thank you for the invitation. I think my presentation will build well on the prior presentation. So Professor Zhao gave an overview of the development of space law and the instruments that exist specifically to address space disputes. I will speak about investment disputes in the space sector. So these type of disputes do not rely on a framework that was specifically built for the space industry, but rather analyze whether the existing international investment protection treaties can be used to protect space investments. And to start, I will give an overview of the space industry today so that we all know what we are talking about. Because I feel like sometimes when people think about space, they think about an article they read about space mining or space tourism, but not many people are aware of the scope of the space industry that exists already today. So the space industry still mainly relies on satellites, and satellites are used for three main purposes, which is telecommunication. Now, for example, there are several constellations that are planned or already being launched to provide broadband internet through low Earth orbit satellites. So satellites that are in the lower orbits around the Earth. They are circulating and they provide constant internet to different parts of the world. So that's one application of satellites. Then we have remote sensing and Earth observation. So there are more and more constellations that are being launched that take pictures of the world at like certain intervals of time, which are becoming more and more frequent, and the cameras that are being used are better and better. So we basically have images of the entire world that are being produced all the time. And now with the artificial intelligence, it is becoming easier and easier to analyze these data and this data in real time, which opens up completely new possibilities for new applications. So if you want to be a founder of a new app, taking into account the availability of this new data is a good way to go, because some of the apps we have today that have become omnipresent, like for example Uber or Uber Eats, also rely on satellite data and were not possible before satellites were being used. So now we have this new application of satellites that is becoming more and more available, which is a good opportunity for businesses. And the third application of satellites is geopositioning, which is what Uber, for example, uses to provide their services, which basically relates to navigation. So we have these three main purposes of satellites. Then on top of satellites, we have the upstream infrastructure that is necessary to put the satellites into space, which means mostly rockets to launch satellites, spaceports, so the places from where they launch, and then all the services they need. For example, now there are companies that are working on refueling satellites already in space, repairing them. There's a whole question about what is happening with satellites when they're decommissioned. So when they no longer work, there are now companies working on trying to have solutions, for example, of taking them out of their orbits so that they don't disturb other orbits, other satellites, etc. And then we do have space mining. So there are companies already working on mining projects, but it's not just, for example, going to an asteroid and taking out precious metals and bringing them back to Earth. What's actually done today is more seeing how the resources that are being present in space can be used in space to further other activities, be it manufacturing or travel into deep space. So there are companies, for example, looking at mining the moon, and the idea of this would be to use the moon as a base for further activities. And in general, the return to the moon is also an important part of the space economy today. There are several projects that are being undertaken to return to the moon, establish a permanent human presence on the moon, and then take it from there to see what else is possible. And we also have manufacturing already. So this is still at an experimental stage, but there have been discoveries, for example, that you can produce human organs in space in a way that is not possible on Earth because of the microgravity environment. So this is also a really interesting area of the space economy, which is particularly relevant to pharmaceutical companies. And then we do have space tourism, but as of now, this only concerns very few individuals, and it's not a big part of the space economy. So just to put it into perspective. And now coming back to investment protection. So in foreign investment protection relies on giving protection to foreign investments, as the name already says. So you don't protect investments. I mean, states are not obliged to protect investments from their own citizens or companies under the foreign investment regime, but rather protect foreign investments that come into the host state. And then the question arises, do we have foreign investment in the space industry? And yes, we do. The space industry is very international. There are many cross-jurisdictional links. And so, for example, there are companies from one state that apply for launch licenses in another state. Satellites are being produced in one state, launched from another, operated from yet a third state. Companies, for example, apply for frequency licenses that are needed to operate satellites in jurisdictions that are more favorable for them to get the licenses, not necessarily in their home states. So we can see that there is foreign investment going on. And so the question that is becoming more and more relevant for these space operators is whether the investment regime that is available for investments on Earth is applicable to the space industry. At first view, the obvious question would be yes. Why would you make a difference between the space industry and other industries? To be covered by an international investment treaty, you need to fall under the definitions that are contained in the treaty, which usually contain detailed definitions of what it means to have an investment and be an investor. Often these definitions require a certain amount of being invested, a certain duration of an investment, etc. Because space projects usually are long-term and require a lot of resources. There's no obvious point where you would say, no, they would not be covered by most treaties. Obviously, this is an analysis that needs to be done treaty by treaty and always refer to the specific circumstances of the case. But in general, you could say that most investment treaties would cover space investments. But then there's one complication, which is that a lot of the investment treaties require an investment to be made in the territory of the host state. And this is where it becomes complicated, because outer space is outside of the territory of any state. So for example, if you launch a satellite into outer space, arguably you could say you have not invested in a specific country because you invested in outer space and your investment is not physically located in another state. But this kind of ignores the fact that all space activities have a clear territorial link to at least one country. So for example, if you want to launch a satellite, you always need a launching license. You need a license to use the frequencies that are needed to communicate with your satellite. I mean, you need but mostly those two. But for example, if you want to manufacture, you also need a license to manufacture. If you want to mine in outer space, you need a jurisdiction that gives you a license to mine, etc. So there's no investment in outer space that is completely disconnected from any host state. So you could argue, and this is theoretical because it has not ever been addressed yet in an actual case, but you could argue that for any space activity, you could probably find an appropriate host state. So then you could say that there's no obstacle to using international investment agreements to protect space investments. And then if you look at the substantive protections that are available for foreign investments in the space industry, once you overcome the jurisdictional obstacles that I mentioned, the protections would probably apply to space investments in the same way they would apply on Earth. Let's say a company gets a mining license, or let's say like a Korean company applies for a mining license in the United States, gets one, goes to the moon, starts mining, and then has like a safety zone set up around their mining activities, and another company comes and says, no, you cannot have your safety zone here. I also want to mine, and disturbs these activities. You could probably have a case against the United States in the same way you could if that happened on Earth. So once the jurisdictional obstacles are overcome, arguably, probably you could have similar, or you could imagine similar cases related to the space industry as you could on Earth. And so far, there have been 3 investment cases related to the space sector, but all of these 3 cases are not really addressing issues related completely to space law or to activities in outer space, but rather address questions related to concession agreements and licenses in exactly the same way cases do that arise in other industries. So there have been 2 cases against India, Deutsche Telekom versus India and Devas versus India. Both of these cases relate to an investment that was being made that required access to S-band frequencies. And India had signed a contract to provide access to these frequencies that was then cancelled for national security reasons. And the tribunals had to analyze to what extent India had the right to use these frequencies for their own national security, or was obligated to provide the access to the foreign investors they had already granted. And the third case is Eutelsat against Mexico. And that case related to orbital positions. So Eutelsat had access to geostationary positions that were granted to Mexico, and Mexico then gave them to a private investor. And the case related to the conditions under which these orbital positions were being provided to the investor. So as you can see, there are already investment cases in the space sector. To the extent that activities in outer space will develop, it is likely that we will see cases that maybe will address more the intersection between international space law and international investment law, and will have to analyze the territorial question that I mentioned in the beginning. So this is a quick overview. I don't know if there are any questions. If not, I will hand over the microphone.
Thank you. Thank you, Ms. Zielinski. I have one quick question relating what you've mentioned right before. I'm not sure if you could, or if this is a right question, but do you think the tribunals will be willing to take a flexible view regarding this various connecting factors like frequency licenses or maybe ground control stations? Or do you think might parties start raising territorial objections more forcefully in future space-related claims? What are your maybe views?
I think
insights?
as always in investment cases and all arbitration cases, I think it will depend on your tribunal. If you pick the arbitrators accordingly, probably you are more likely to get a certain result. I mean, there are arbitrators who might take a more flexible position and others who are not, depending on their background and academic leanings. So I would say.
Oh, I see. I also wanted to ask you, these space activities, as you've mentioned, they often transcend national boundaries and involve multiple legal regimes, from international treaties to domestic regulations and private contracts. In such a complex environment, what are your thoughts on how the arbitral tribunals should approach the question of applicable law? And do you see any role for the public international law principles within commercial arbitration of space-related disputes?
Well, I mean, in international investment disputes or cases under international investment treaties, the applicable law is only public international law. So then I would assume that arbitrators would not be obliged to look at international space law, but I think it would make sense for them to address any principles that exist under international space law as well. In commercial cases, it depends on the case, but I think they will have to probably take into account international space law, international telecommunications law, and I mean, public international law as such, generally maybe not, because it's commercial, in commercial cases, but I think it would make sense for them to look at the solutions that are being offered by international space law, because you cannot really judge any commercial activity outside of the applicable legal framework.
Thank you. I see. I don't think we have any questions from the audience, so can I have the privilege to ask you one more question? If I may ask on a more personal note, I actually found it very remarkable that you took the initiative to establish the Space Arbitration Association. Could you share with us maybe what the decisive moment or motivation that led you to take the step?
Yeah, of course. So I was based in Mexico for the last 8 years, and I was working on a big investment case in the space industry for a few years when I first started working there. And then the pandemic happened, and in Mexico we were quarantined for many months with not much to do. So I attended a space law course at McGill with a certificate in strategic space law, which during that year of the pandemic was online, so it was easy to do from Mexico. And that got me more and more interested in the space sector. And I noticed that as Professor Zhao also mentioned, there have been initiatives already trying to address dispute resolution in the space sector. And a lot of space professors do have an opinion on international arbitration and how arbitration can be used to serve the space industry. But I felt like there was not a lot of interaction between the space law community and the arbitration community. So I thought it could be a good idea to have a forum where we could have these types of discussions to see like what mechanisms work well for that industry and what not. So that's why we started doing a conference series where we tried to address several aspects related to these topics. The recordings are still available on our website. And there's also, for example, a list of all the publications that have been written on the space sector and dispute resolution. And we now also have a blog, so if anyone is interested in writing something, please let me know. And yes, that's where the idea came from.
Oh, thank you. Thank you so much for delivering such an excellent presentation despite the very late hour in your country. I think we have no other questions. So with that, let us now turn to the final speaker of the first session, Ms. Dreosti. The floor is yours.
Terrific. Thank you very much. And thank you much to the presenters that have gone before me. Because there's a lot that I now don't need to cover, which is terrific. And the angle that I'm going to look at is a lot more on the commercial side in terms of what space participants are putting and can be putting in their contracts in terms of how they resolve disputes, with a particular focus on multi-tiered dispute resolution clauses and the pros and cons of using them in the space sector. So in terms of the presentation, I'm going to start with what is a multi-tiered dispute resolution clause, and then run through looking at how they operate in an industry that we know has had some monumental changes with that shift from old space to new space, and what that looks like for participants, and also then some of the risks around an imbalance of bargaining power, the challenges where you might have conditions precedent going through your multi-tiered dispute resolution clause, and then the interdependence of those clauses, and then looking a bit more closely at some of the more adversarial steps later in the piece, for example, expert determination, And of course, because it's an arbitration day, concluding with looking at arbitration and how it works for the space sector, but more on the commercial side. So starting first off in terms of what is a multi-tiered dispute resolution clause. So this is basically an escalation clause where you might start by trying to resolve the dispute as amicably as possible. And certainly for the space industry, this has particular appeal because it is a notoriously wonderfully collaborative sector that would like to avoid formal disputes. So it can start with a negotiation phase. If that negotiation phase among senior executives doesn't resolve, it may then escalate to mediation, where you're having an independent third party coming in to moderate the matter, so to speak. And then that can go through to expert determination, where you have, again, a third party independent that might have particular expertise in the sector, whether that's a lawyer or that's an engineer that's worked, that really understands some of the technical issues that are at play. And if that doesn't then resolve, then the dispute may go to arbitration, most commonly for cross-border disputes. And I think everyone is well across the attraction of arbitration in the cross-border arena, but obviously there is scope for some clauses to provide in contracts that it goes to litigation. And that's probably a discussion for another day in terms of some of the challenges around litigation. And the real advantage of the multi-tiered process is that ability to filter out disputes, so to speak, with the intention really being to resolve the issues at an early stage. And that's a real attraction for industries like the space industry, and it's not unique to the space industry, certainly across other sectors like construction and infrastructure projects. Multi-tiered dispute resolution clauses are very much a common feature because they're geared around, in some instances, very long-term contracts, very long-term procurement projects. And so what's wanting to be avoided is trying to avoid as much as possible disruptions to ongoing operations, and really being mindful about the long-term nature of a lot of these commercial relationships and the best way to keep those relationships intact, to keep the dialogue going, rather than the full escalation of what can be a very acrimonious formal dispute process. But what is really interesting that I wanted to look at in particular today is the use of these multi-tiered clauses, where you now have very, very different players in the sector. So obviously we know that previously and historically, and Professor Zhao has touched on this as well, space was very much the domain of space actors only, and we've seen that reflected in the 5 space treaties that both of the previous presenters have covered. But we now have a shift. We now have the new space ecosystem. We have private funding coming in as well. So there's the whole piece in terms of private equity, venture capital, etc. What they're putting into the industry, what happens if they have disputes as well. So there's just a much broader group of people now playing in space because of new space. And I was directed to quite a useful Washington Post article that compared the two approaches and said that old space is slow, bureaucratic, government directed, and completely top down. It's cautious and halting, supervising every project down to the last $1,000 widget. And then it contrasted and said, new space is the opposite of all that. It's wild, it's commercial, bootstrapping, imaginative. I think there are actually some quite entrepreneurial people that are in old space, so I wouldn't take it too much to heart, but it's a good observation that there are companies and organizations coming from a very, very different angle. And if I think, for example, to the space legislation in Australia, as one of its key goals is really to encourage entrepreneurship in space, to encourage new entrants. So now we have this really interesting juggle between all of those different players in the sector in a way that we may not see in a lot of other industry sectors that are using multi-tiered dispute resolution clauses. And if we look now at some of the pros and cons of those multi-tiered dispute resolution clauses And bearing in mind that quite often when we're talking about some of the new space players, we are really talking about small startups. We're talking about people with sensational, brilliant ideas, inspiring ideas that are then entering into contracts with some of your biggest players in the industry. So some of your mega aerospace and defense companies, and also obviously the likes of SpaceX, Blue Origin in terms of the launches, the launch power as well. So that's the mix that we're then looking at. So there is a real attraction if you can resolve your dispute at the negotiation stage. There's not too much skin in the game, so to speak, in terms of costs that you are sinking into the dispute resolution process. So that is where you can have a real attraction to the process. I can imagine as well that there can be some dangers of the process if you have a David and Goliath situation and you have Goliath that is wanting to slow down the process, then there is obviously a lot of step throughs in a multi-tiered dispute resolution process. And if you, and I'll come to it in a minute, if you add in particular layers of the more formal processes in there, for example, if you have an expert determination, which is in effect a mini trial, and then a further step that could go to arbitration, that can be very challenging for a very, very small player that is wanting to escalate a dispute all the way. Some of the other challenge is also around actually just the drafting of these clauses, and there's been a number of cases in Australia and throughout the world in terms of that ability for lawyers, private practice lawyers, to have a dispute about how to have a dispute, and cases that have really all gone to court in relation to whether or not the dispute resolution process has been followed correctly, whether or not a case can proceed to arbitration when the parties were meant to go through mediation beforehand. And so again, that's probably one of the traps and tricks of dispute resolution processes, is precisely around that drafting, in terms of if one of the clauses is found to be unenforceable, what does that do for the rest of the clauses in that agreement? And one example that I had in the courts in Australia was where there was an obligation on the parties to negotiate in good faith, and an argument by one of the parties to say, well, good faith doesn't have a meaning as a matter of law in Australia. And obviously I appreciate there's very different approaches to good faith around the world, and in civil law countries it's codified. But again, that's probably a discussion for another day. But that was the argument, that as at that time in Australia, it wasn't sufficiently certain such that the clause was unenforceable. That argument wasn't successful, but it's a good example in terms of being mindful of the interdependence between clauses as they go through, and because of that, making sure that each clause can stand on its own, and really ensuring that if there is a multi-tiered process, it can accelerate through as the parties intended, rather than being caught up. And to bring it then round a bit more to the space sector, obviously there are lots of different ways of structuring these multi-tiered dispute resolution clauses. Laura mentioned a little earlier the Davis and India cases that have certainly, from a straight arbitration perspective, been fascinating in terms of then the enforcement processes that have gone on around the world, the investor-state arbitrations that have been started in relation to it, as well as the ICC commercial arbitration that came out of that dispute. And that's quite a good example in terms of the dispute resolution clause, as we understand it, required that initial step of senior management to meet first before the dispute could escalate. And there was a challenge in that scenario where one of the parties attempted to start that process and there wasn't a response in terms of then engaging in the negotiation. And none of that is particularly unique or surprising to the space sector, but it reinforces again the benefits of clear drafting, but also the benefits of thinking through in each contract what is the best dispute resolution process for the parties that are engaged in this project, in this contract. And I think that's the biggest challenge, is that the dispute resolution clause is commonly referred to as the midnight clause, because no one thinks about it at the time. It's at the last minute. It's at a point when everyone is signing their contracts and everyone thinks that everything is going to go really well, and the need for it to be thought about sooner. And I think the space sector as well is particularly exposed in that regard, because it's what attracts all of us to the space industry. It's what attracted me in the first place, is that real sense of collaboration, extraordinary research and development projects spanning multiple countries, and that real willingness to collaborate, but needing to bear in mind when we are talking about billions, millions or billions of dollars, often a lot of these projects, prudent planning requires that there is an enforceable dispute resolution process that is put into place. One sort of particular topic that I wanted to touch on as well was in terms of expert determinations, and certainly there's been a trend that I've seen about the insertion of expert determination processes into the dispute resolution phase, or in some circumstances where it's been drafted in as the final phase. Again, expert determination can be incredibly useful where you have an expert coming in to resolve a specific technical issue. But the challenge, and often that is the case with space technology, it's incredibly complex. It benefits from a decision maker that understands some of the technical aspects of what is in issue. But the challenge with expert determination really comes in terms of enforceability of that decision, that even if the parties agree that it's final and binding, it doesn't have the imprimatur of court decision or the enforceability that we have with arbitration, with thanks to the New York Convention, the ability to enforce that. So the challenge with expert determination is that often then it's another process to the courts to have that expert determination recognised. That's very difficult where you're dealing with a cross-border contract in terms of involving the courts there. But there's an additional issue, and again, touching on the costs aspect of it, that expert determination can also often be inserted just prior to arbitration or litigation. And the risk there is that it is then a mini process in effect, with the expert trying to make a decision often within an incredibly limited time frame of 10 business days or whatever the parties have agreed. But in that compressed timetable, the parties are still having to put on full submissions. They might be trying to pull in all the evidence they can as well. And invariably, someone is not going to be happy with the expert's decision and will then be referring it up the chain to arbitration or to litigation. So it's certainly a trend that I've seen in some sectors, some pockets of the space industry, that I have some nervousness about. It's not always the great solution, even though there is that tech feel to it, because it's involving someone with those technical skills. So that's very much a quick canter through, because I'm very mindful of the time, the application of multi-tiered dispute resolution to the space sector. I think certainly some of the other conventions that we've touched on have features of arbitration as well, and certainly a lot of those multilateral agreements, arbitration is the end dispute resolution mechanism, logically, as you all know as well, because of the enforceability of those awards. But I think as well, we are needing to see, with that shift to new space, a need for speed. And that comes back to what Professor Zhao was saying at the outset, that need for online dispute resolution, the fact that new space is moving so much faster, that some of those previous processes, and certainly the liability convention is an example of that. That's very much as between states. It provides for a claims commission, which is somewhat similar to arbitration, but there isn't real teeth necessarily at the end of that process. And so I think it's a good opportunity for space to think about really making tailored solutions, both for the space sector, but also for each and every contract, giving it some really careful thought. Any questions?
Thank you so much, Ms. Dreosti. I have one question. In recent years, I'm aware that the expedited arbitration is becoming more and more popular, especially when urgent relief is needed. And some arbitral clauses include emergency arbitrations. But in space disputes, at first glance, one might think that urgency is less of a concern, while technical expertise is more crucial. So do you think such cases inherently call for slower and more detailed proceedings to ensure adequate consideration of the technical complexities involved? Or do you think expedited arbitration is also possible in this sector too?
I think it's probably very much a horses for courses in terms of what's the issue. There are obviously natural limiters around the expedited arbitration process that constrain it both in terms of value unless that's agreed. But also I think in the space sector as well, while some issues might need to be properly ventilated from a technical perspective, there are just other issues that arise with the same urgency in terms of launch, or if that's in terms of M&A activity and what's happened with those assets, that does require a really urgent response. So I think it's an excellent question in terms of the importance of space participants being aware of the full toolkit that is available to them. But I certainly think that it is one that space participants can use just as much as in other sectors and should be aware of.
Yeah, I totally agree. Okay, if I may, I'd like to ask you a bit more of a general question.
Sure.
Without asking you to disclose anything confidential, may I ask whether you have actually handled a space sector dispute case in practice? And if so, what would you say was the most significant difference compared to more traditional arbitration sectors such as energy or construction?
So I have my difficulty is because it's so collaborative, it didn't go all the way to hearing. So I certainly can't in terms of tell you sort of from the start to finish, but that's also not unique to the space sector in terms of a lot of disputes you will resolve. You might, resolve them just before you're going into hearing. But in terms of the experiences on that matter, a lot of it really wasn't that different. And I think that's probably the benefit of working across sectors, working also obviously in aerospace and defence that has some similarities, but also in your broader construction infrastructure sectors that ultimately they can be quite complex contracts. It's in all of those sectors very complex technology, but ultimately they are not as different as they think. So I think all of the sectors that I work in generally involve engineers. And that's probably the one unifying theme that I actually find really rewarding across the sectors. But no, certainly in my experience, it hasn't been such a striking difference. There are obviously differences in how liability and risk is apportioned in space contracts, and that's some of the differentiators. That has some alignment with your oil and gas contracts as well. So that's perhaps where you see sort of a few more nuances as compared to the risk allocation and balance in some of your more conventional industries like infrastructure.
Thank you for your response. If there are no other questions, I think, okay, we could move on. I found Ms. Dreosti's remarks to be particularly valuable from a practical perspective. Thank you once again. With that, we have now heard from all the three panelists in this first session, from the scholarly authority in academia to the founder of a space arbitration institution driven by passion, and finally to a leading practitioner with unmatched expertise in dispute resolution. I believe our audience has taken away many valuable lessons. As a young practitioner myself, I also found today's discussion very motivating, and it has strengthened my resolve to contribute further to this exciting field. I also believe that this session holds particular significance for legal practitioners in South Korea. Since the launch of Aerospace Administration in May last year, interest in this prevention and resolution of space-related disputes has grown markedly in Korea, yet the number of domestic experts in this field remains limited and discussions have been scarce. So in this light, I believe the insights shared today by our three wonderful panelists have been especially valuable for legal practitioners in my home country, including myself. So once again, my sincere thanks to our distinguished speakers and to all the audience for your attention. With this, I'm pleased to conclude our first session. Thank you all for your time.
Thank you, Ms. Lee. I express my greatest gratitude to our panelists, Professor Zhao, Ms. Zielinski, and Ms. Dreosti, and our moderator, Ms. Lee. The insights they have shared truly inspired me and have elevated my understanding on this important and delicate topic. I'm certain that the audience would have felt the same. Now, a brief intermission is upon us before we move on to our second session. We will recommence in about 6 minutes at 11:30 a.m. KST. Thank you. Welcome back, everyone. It's time for our second session, Tips for Young Practitioners, Foundations and Pathways in International Arbitration. Our moderator for this session is Miss Yoo Jung Lee from Lee & Co. As the former president of the Yonsei International Arbitration Association and a co-host of YAD 2 years ago, she returns to this event as an associate, making her the perfect moderator to guide us through the session. Please welcome Miss Lee.
Am I audible?
Yes.
Yes,
Can hear
thank you for the kind introduction, Byung-wook. Good afternoon, good morning, and good evening to everyone joining us from across the globe. I am delighted to welcome you to today's second session. As introduced, my name is Yoo Jung Lee. I am an associate at Lee & Co.'s International Arbitration team, and I am also a proud alumna of the Yonsei International Arbitration Association. A few years ago, I was in the host seat for this very event, so being back here today as a moderator feels quite surreal and deeply meaningful to me. Alongside our amazing panelists, I will try to make this session as meaningful and inspiring for you as it is for me. So while our first session was on arbitration and the space sector, now it's time to come back to Earth and turn to a topic that is both highly practical and directly relevant to many of you, especially this being a student-organized seminar. This session is titled Tips for Young Practitioners, Foundations and Pathways in International Arbitration. Today, we have an outstanding lineup of panels ready to share their invaluable insights and experience for young practitioners. To introduce them briefly, first, although he needs no introduction, is Mr. Joel Richardson, senior member of the International Arbitration and Cross-Border Litigation Practice at Kim & Chang. Mr. Richardson has represented clients in commercial arbitrations under nearly every major arbitral institution you can think of, and across a very wide range of seats and industries. His breadth of experience makes him the perfect fit for this session, and I am certain you'll walk away with an abundance of practical and actionable tips from him. Next, I am equally thrilled to introduce Ms. Leah Njoroge, legal counsel at ICSID. Ms. Njoroge began her career in an international arbitration firm in Nairobi, and then joined ICSID, which, as many of you know, is part of the World Bank Group. So, having worked in both commercial and investment arbitration, and having experienced life at both law firms and arbitral institutions, she brings a very broad and unique perspective to the discussion. Personally, I'm very excited to hear her take on navigating these different worlds. Last but not least, I'm delighted to introduce Ms. Youngshin Senior Counsel at KCAB International. I know there are quite a few Korean students and young practitioners in the audience today, and I think you'll find her journey especially inspiring. Previously, Ms. served as Senior Deputy Director at the Korean Ministry of Justice, and before that, she also practiced in the arbitration teams of a few Korean law firms. So, as a Korean lawyer with experience spanning private practice, the government, and an arbitral institution, I have no doubt she will share valuable stories for both of you just starting out in the field. So as a quick reminder before we start, you can submit your questions at the Q&A section below, and we have reserved some time for each panelist to address your questions at the end of this session. Okay, so to get us started, I would like to ask each of our panelists the same opening question. Could you briefly share how you first got into international arbitration and what drew you to this field? Perhaps we can start with Mr. Richardson and then hear from Ms. Njoroge and then Ms. Thank you.
All right, and thank you for the invitation. I'm quite happy to be speaking to this audience. I'll say I won't bore you with the full story of how I got into the position I'm in, but I will say that my history with the law dates all the way back to at least second grade, where at that point I was certain that I would be a litigator. I started practice in Washington, D.C. With quite a large firm doing domestic litigation, predominantly in federal courts. and really knew nothing about arbitration. At that time, when I started law school nearly 30 years ago, arbitration was something not really taught at most American law schools. We didn't have the arbitration moot court. I did the Jessup International Law Moot Court because that was the only international moot court. So I didn't really know about arbitration. And when I was taught ADR, it was essentially mediation. After a few years, I decided I wanted to move to Korea and knew I would be coming here as a litigator and wasn't sure exactly as a foreign lawyer what that would be, being a litigator in a foreign country where I don't have rights of audience. But settled very quickly into the arbitration practice and found it actually was a much better fit for me, in part because in U.S. court, cases don't end. They just extend. I think in my time practicing in DC, I had precisely one case that went to a final judicial decision. Other than that, all of the cases either settled or in most cases just dragged on and on and on. I know people who have spent the better part of their careers on one single case, spending almost all of their time on one case for one client because it just keeps going. And arbitration, when I started here, we would tell clients, it really, practically speaking, most cases were about 18 months to 2 years. If a case was really long, it could go 2 years. I don't think we tell clients that anymore. Cases tend to go longer than that. But still, most cases can be resolved within 3 years, which is extraordinarily rare in US courts. So I've enjoyed the process quite a lot, and I've come to learn that Korea is home. I came here, my wife and I made each other swear on a stack of Bibles that we would live in Korea no more than 2 years. We'd move back to the States after 2 years, and I have no thoughts of where I will live next. This is where I'm going to live the rest of my life, I think. So, and arbitration is a great way to spend it.
Thank you,
I think that's nothing more to add.
Should I go in? Okay,
Sure,
great.
thank you.
Well, as you've heard, my name is Leah Njoroge. I'm originally from Nairobi, Kenya, and my story is quite interesting. Like Joel, I did decide quite young that I wanted to be a lawyer. I think I was 12 maybe. And at that time, I thought I was just attracted to the, the glitz and glamour of being a lawyer. But I soon found out that it required, a long nights, and I wasn't too sure of my decision. So anyway, fast forward to how I got into arbitration. Towards the end of my undergraduate, I really was focused on international economic law, and I wanted to study WTO law. And my background is actually in trade law. So I was drawn to that area of the law. And so I studied and I did a master's in economic law and in Switzerland. And so that was the first time that I encountered investment treaty arbitration, and I got excited again. And I thought that I could merge the two, that I could do both trade law and also investment treaty arbitration. So at the back of my mind, that when I finished my master's, that's what I wanted to do. And really, the options were very few for me when in Switzerland. So I did an internship with UNCTAD, and then after that, it was time to go home. And what I just did, I didn't know that there were any arbitration law firms in Kenya. So I just applied to the top law firms that I knew in Kenya. And lucky enough that one of the top law firms that asked me to interview for them had just opened an, I would say, a sister firm that was purely arbitration and international arbitration. So they interviewed me for the position and I got it. And I just like that, I started working in arbitration. And we had clients, both domestic and international, dealing with a wide range of interesting cases. I traveled all over Africa. I think I went to like 10, 15 countries just representing clients. And that was just the glamour maybe that I was looking for when I was 12. But that's how I got in. After J. Miles and Co., I really wanted the arbitration experience. Yes, we were representing clients, but I think in Africa, the part that I'm from, it's very rare that you get exposed to more international, diverse client. So I wanted that exposure, and because I had no other training outside of Kenya, so no other jurisdiction that I had practiced in or qualified for. So I decided to maybe seek an institution. And so when a position opened at ICSID, I applied and I was selected. Well, 6 years later, I'm still at ICSID. I love what I do because I've seen both sides, like you said. Yeah, that's it.
Thank you for your story, Ms.
Thank you. I hope everybody hears me well. And thank you for the kind introduction. I'm really glad to be back to the Yonsei Arbitration Day program. I believe it was 3 years ago or 4 years ago that I was first invited. But thank you very much for having me again in this important panel. As Ms. Lee mentioned, I am the only Korean licensed attorney in this panel. So I may bring some insight or input to the Korean law students. I first started my law studies in my college. I didn't know what I really wanted to do by that time, but then I wanted to study international human rights law and become a legal officer in one of the international organizations. So unlike the traditional Korean law students back in old days, I went to US and I went to US law school to study international human rights and to become a US licensed attorney. But then I figured out that it may be better to become a Korean licensed attorney rather than a US licensed attorney. So then I returned to Korea and then I graduated from Korean law school, and I am the first generation of Korean law school, the new legal education system. But still in law school, I didn't really think seriously about international arbitration before I met my professor and currently my boss in the institution who wanted to teach international arbitration to the students and try to encourage the students to participate in the VISMUT. So I did not know what an international arbitration was, but I was chosen as one of the members of the VISMUT team. And that's how I first got exposed to international arbitration. Even after graduating and being licensed to the Korean bar, I didn't want to practice the private, practice in private practice. However, but things happen. So I got a job in a law firm, but due to my certain backgrounds in international arbitration in law school, I was allocated to international litigations or international arbitration cases that was being handled by the firm that I was working for. So that how I started. And then while I was practicing, I felt like I should study more because I think I was educated in Korea, so I thought that I need to get some more professional training in this regard. So I did another LLM after 6.5 years of practice. And when I was doing my second LLM, it was full of investment arbitration in New York at that time. So and then the government was looking for experienced attorney who is to handle investment arbitrations filed against the Korean government. So in 2020, I joined the Korean government and was in charge of handling investment disputes, as well as representing the Korean government in various forums, such as ICSID rules reform, UNCITRAL working groups, which deals with international investment arbitration. Now, since as of late March of this year, I moved to KCAB International. I'm currently working as a senior counsel in this arbitration institution. Thank you very much.
Thank you. As a fellow Moody, that story very resonated with me. And thank you all for sharing your stories. It's always inspiring to hear how different paths led to the same field and to the Yonsei Arbitration Day today. So let's move on to the skills side. Mr. Richardson, from your perspective, what do you think are some key skills to become a successful arbitration lawyer, and how can young practitioners work on these? Sorry, I think you're on mute.
Sorry, I just noticed that I'm on mute. When I was I joined Kim and Chang as an associate, and when I joined, one of the partners advised me that there are really 3 core skills you need to develop to be an arbitration lawyer. You need to write well, you need to be good at public speaking to present yourself well at hearings, and you need to network well in the community. I don't think those are the only 3 skills, but I do think they're 3 very important skills. And I think for all of them, the key is practice. I think writing well is something you learn to do by doing repeatedly and won't come easily at first. And I've stuck to another piece of advice that I was given as an associate that I try to live by ever since then is you should be published at least twice a year. You'll do a lot of work in writing persuasive pleadings in a law firm once you get a position. And that is a different thing than published writing. Persuasive writing is different than academic writing. But both of them, it's very important to keep your skills as a writer honed. And it is actually not that difficult to be published in the arbitration field if you can think of creative topics. I think if you can come up with a good topic, do some research, write something, write somewhere between 2 to 10 pages and submit it. There are lots of great journals out there, including the KCAB journal, that are looking for good publications. And I think those opportunities are there. On public speaking, I thought when I came to Korea that I had learned that skill. I did that as a litigator in the US. And then I got a position teaching at the Sabapyeonsoan, lecturing to a class of between 70 and 90 students. And on my first day in class, I sat at the desk, I stared at them, I looked at a sheet of paper. I don't think I ever made eye contact. I think it was the most boring class anybody has ever had to sit through. And I realized it's just something you have to learn through repeated practice. And eventually you'll learn, if you're talking in front of a group of people, you're probably there and they're probably there because they want to hear what you have to say. They're probably not going to throw anything at you or shoot you while you're talking. It's not dangerous to do. There's no reason to be nervous doing it. And you'll learn to think through the process if it's something you do over and over again. And I think in the US, there are actually societies you can join to do Toastmasters, to learn to give toasts and do public speaking. I don't think you have to do that, but I think within your arbitration team, we at Kim and Chang have every other Thursday have a meeting of the entire arbitration team where somebody will teach a course essentially to the team about a recent case or a new development. Just doing that gives you a chance to get up in front of a group of people and speak and be heard. And both of those 2 things, the practicing your public speaking and the practicing your writing, help with the 3rd thing, which is be known and know the community. For better or for worse, arbitration is a little bit of a clique or a club, and being known among the club does make a difference in how you get treated. But also you have to pick arbitrators for every case, and being able to give input to your team and your clients on who are the good arbitrators for this specific case. It's very important. And that's a skill you learn by meeting people in the community. So attend events. And one of the advantages of Seoul is a place that has a lot of arbitration events. And I think KCAB Next is rebooting and we'll be having many events over the next year. Attend as many as you can. And if you can, talk to people at the coffee. You know, when I attend a conference, the actual seminar sessions, the lectures, I no longer look at those are very important. If there's a specifically useful topic, I'll make a point to be there and take notes. If there's a topic that I feel like, okay, I've heard this so many times, I don't need to hear it again, I'll take time outside to meet with people, other people who are attending or people in the area. But the coffee breaks are extremely important, because at the coffee breaks, you can meet the people and get to know the people you're going to be working with, whether at your firm or other firms or clients. And I think that's very important to both to build your own profile, but also to get to know the people who you're surrounded with. So you can know, for example, who to pick as an arbitrator. I think I've probably gone on longer than I should, so I'll probably leave it at that.
Thank you so much for your insight. First of all, practice, 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 and publishing twice a year. I've actually read quite a few of your articles, so now I understand why. As a junior myself, I really feel that these skills are some that I should hone myself. And now with some skills definitely come challenges. Ms. Njoroge, what are some common mistakes you see young practitioners make, and how can we avoid them? Thank you.
Thank you. Thank you so much for that question. And I omitted to say that while you guys are starting your day, I am actually winding up my day. So apologies if I sound like, very wary, but it is nighttime for me. However, I wanted to say I mentor interns at ICSID for my team. I am assigned to one of the case management teams at ICSID, which is we call typically the English team. And for the last 3.5 years, I've been mentoring all the interns that come to our team, that are assigned to our team. And one thing that I have seen from every intern that comes in is that I hate to bring up the word networking, but I wanted to look at it from a different dimension than what Joe talked about, conferencing and other things. The networking bit that I wanted to talk about is that the people who are going to give you your next opportunity are most likely going to come from the people who already know you. Like, these are the people who you've worked with, for example, in a past position, or people who have known you from school and have, heard about you and the work that you do. So I think that some of the failures that I have also seen in my practice that I maybe didn't do quite well is to warm up those relationships and to keep tabs on the people that you know and who know you and are likely to give you your next opportunity. So, and I see this has happened quite a bit. Some of the interns that have been at ICSID have gone on to come back as counsel simply because they just kept those relationships alive. And so I think that's one thing that you need to understand, that that yes, it's the work that you do. Your work, yes, should be top notch. You should definitely get an opportunity based on merit, but the people who are going to think of you for
I think there is a slight glitch right now. Is that just me?
do you hear me now?
Yes, I can hear you again. Thank you.
Okay. Right. I will just say that, yeah, networking at every opportunity. The other thing that I would like to say is the one thing that I do note about young practitioners is that some of them put so much emphasis on the education part of arbitration, which is go get a master's, go get a PhD, go get a this qualification. I need to attend this class, or else I won't feel like I'm good enough for arbitration. I feel that is you're second guessing yourself. I feel like from my experience, having worked in arbitration for 10 years, is that arbitration is a very specialized area of law. And I think the more you practice, like Joel said, by doing the thing hands-on, by actually attending a hearing, by actually getting a job in which you will be, as your skills will be tested, I think that would be the thing that I find that most young arbitration specialists concentrate too much on. I gotta have that certification, or else, it's not gonna work for me. And sometimes it is important because maybe for you to get validation in a different jurisdiction, you do need to get a higher degree so that you can qualify to be admitted to practice law in a jurisdiction. And sometimes even the opportunities themselves require you to have a higher degree. But I would say that once you have like a master's and a higher level degree, which you think is sufficient, find a home base in which you can settle yourself and get a paying job in which you can practice the skills that you have learned. Those are the 2 points that I had. Yeah.
Thank you very much. Keep relationships real, make them last, and focus on hands-on experience. These are definitely points that our audience should take back. And now a question to Ms. Based on your experience, can you give our audience some advice on how to prioritize their developments in the few years, whether it be technical skills, strategic thinking, or professional habits?
Thank you, Ms. Lee. I think there is no specific priority among the three of them because they all go together. Correct me if I'm wrong, because I'm a more senior practitioners in the panel, so they may have different thoughts. But to me, from my humble view, it seems that technical skills, strategic thinking, and professional habits, they all go together. So first of all, as junior associate, I think that learning the basic lawyering skills is the most important if you're willing and thinking of becoming an arbitration attorney, because I believe that basic lawyering skills are nearly the same in various sectors like litigation, or even like transaction or advisory works require reading the documents, analyzing the main issues, and then researching relevant law and cases, etc. So for the first few years, I strongly recommend that you earn the basic lawyering skills at a proper law firm or with a proper senior attorney who can guide you to the right path. And for the Korean licensed attorneys or Korean law school students who are who are sitting for the Korean bar, and if you're going to, even if you're going to become an international arbitration practitioner, if you're going to be an Korean licensed attorney, it is really important that you have the basic understanding of how Korean law works. Because even in international arbitration teams, you will be asked to answer on issues about Korean law issues, for instance, enforcement, how to interpret a contract, or wherever a case is seated in Korea, then you would have to look into the Korean laws. And in the real practice, it is really important to look into the enforcement law issues such as attachment, seizures, etc., because that is a real thing happening in actual practice. So I strongly recommend that basic lawyering skills plus Korean law issues that may be relevant to arbitration proceedings would be the most important thing that you should focus during your first few years of practice. For strategic thinking, I think if you are going to become if you're thinking of an arbitration practice, I think the most important thing is to learn how to understand the entire, I would say, chronology or story of a dispute when it comes. So when you are assigned a case, it would be there would be like pull boxes of documents that you have to go into, because the story starts from like a decade ago or a few decades ago, where the business or where the transaction first started. And then your role as an international arbitration practitioner is to go through the entire history of this proceeding or the case, and then figure out what are the main issues at this particular dispute, and figure out the best strategy for your client. So I think for strategic thinking, thinking wise, it's important to get your own style of thinking and reading the entire story of the whole case or overall dispute. Lastly, professional habits. I first had good and thorough reading of documents in mind. This also relates to technical skills as well as strategic thinking. But as Joa and and other panelists have been mentioning about networking, my own view is that networking is really important, but at the same time, you don't really have to be stressed about networking. Well, so like if you're really good, if you excel in a case, or if you do a really good presentation in an event, then that's the best networking, I would say. Then like afterwards, you will get many people will approach you and will wish to get to know with you, and you will get further opportunities. So and I know that Koreans are quite shy compared to others. So my small tip would be that do not be too much stressed with networking. Just be yourself, get prepared, but you have to be prepared for every opportunity that you get, so that you get the best impression to others, so that you get along and you get the next opportunity. That concludes my presentation on this issue.
Thank you very much for these points. To sum up, I think the key point is that, especially at a junior level, what you focus on is building a strong foundation rather than these fancy little techniques. And as a Korean lawyer myself, a small point that I really resonated with was the enforcement law section. I've been doing enforcement quite a lot, and I feel that students should also study enforcement in civil law more in a more in-depth manner. So shifting gears a bit, Ms. Njoroge, you've experienced both commercial and arbitration investment and worked in both law firms and arbitral institutes. So how did each environment shape your approach to cases?
Yeah, that's a really good question. And actually, I got asked that question not too long ago. And I would say that it has shaped and informed my professional life at this point, because I have seen both sides of being counsel. And when I was counsel at J. Miles & Co. from 2014 all the way to 2019, it was all about the three things that our boss would tell us every single day: finding, minding, and grinding. And it was all about find the client, mind them, and then do the work. So it was all about that. And that was the life that we led for the most part as an associate. And it's a different kettle of fish when you move into the institutional aspect, which is you're representing the institution. Your role is to support the Secretary General and the institution itself. So in a way, it's more of a diplomatic role, and you do have to neutralize your language in many respects. And sometimes you also may not have, a partisan view on anything. So yours is to support your clients. And mentioning clients, my clients are totally different. My clients are the parties, are the tribunal members, and so in that respect, it's very different here. It's the client-facing aspect of commercial law and commercial arbitration is very different. My approach is very different. There, it was all about how can I win this case for my client? What necessary steps do I need to get? How can I give the best advice possible given the circumstances? And differently, I do give advice, and I do give advice to my clients who are the tribunal members, and I tell you, given these circumstances, what's the best approach that the tribunal can take? And so I've had to question a lot of my personal opinions, and while moving from the counsel part to the ICSID part, and just try to balance the two approaches. And so it's just been a very, very interesting journey for me. But I can say that for you to be at ICSID, I feel like the council work or the council role that I did at J. Miles fully supported what I now do. And I now have a fuller understanding. You know, I do understand where the parties are coming from. I know where council is going. I know that, you know, sending emails on a Friday night is like, no, because I was there. I was like, no, we're not. I was there. And so, so in some respects, I do really appreciate the council role that parties play. And as I serve the tribunal members and serve the institution generally, there is an appreciation of the wholesome world that is international arbitration. So that, yeah, that's my contribution. Yeah.
Thank you. That perspective really highlights how environment shapes mindset. And I think this is something that our young practitioners should definitely keep in mind when building and deciding their future career. So, built on that, Miss what do you think cultural awareness plays in international arbitration, being the field that it is? And what practical steps can young practitioners take to build that muscle?
Thank you, Ms. Lee. Honestly speaking, this was the most difficult question when I was when I was allocated with this question, and but I tried my best, particularly from the perspective of a Korean practitioner who was practicing international arbitration. As briefly mentioned, I was I went to elementary school in the States, but like my major education was done in Korea, so I'm fully Korean. My English is not as fluent as like the native speaker, so I think I may contribute on this issue. Because I'm still practicing international arbitration. So for the first part, I believe cultural awareness plays various roles in international arbitration because it itself is a mixture of various like jurisdictions and various cultures. So for communication and advocacy, ensuring due process, negotiation and settlement in every aspect of like every moment, every step of international arbitration or international dispute per se, I believe the cultural awareness plays a vital role. And on to the second part of your question, what practical steps can young practitioners take to build that muscle? I thought about it for quite a while, like what would be the best approach? My answer would be a bit, you may hear a bit passive, but like you don't really have to be so stressed about having like a cultural awareness, because once you're practicing international arbitration, you will get to acquire cultural awareness because you get to work with many co-counsels like in international firms. You may also have like practitioners from other jurisdictions even within your team, or the tribunal members, of course, may be from different jurisdiction. So like by working in this field, you are in the environment that makes you get accustomed to the mixture of various cultures and various jurisdiction. What is more important is that to have an open mind and to have an understanding, understanding attitude for things. As briefly mentioned and introduced by Ms. Lee, I served myself with the Korean government for the past 5 years. And I'm not sure how many of you may be aware of, but the Ministry of Justice is one of the most conservative ministries within the Korean government. And when I first joined, I was the first, almost the first practitioner who has private practice, who has experience of doing international arbitration in private practice. So everything was quite difficult, and even communicating with the international with our counsel who's working for the international firm. Before I arrived in the government, it all went through our local counsel. So the government hesitated not to communicate directly with our international counsel, because they were concerned about having any miscommunication due to language issues. But as a client and counsel, it's really important to have a good chain of communication. So by making those communications directly, and to make those communications efficient and noteworthy, I think it's really important to try to understand how they work, how your counsel, how your colleague working in different jurisdiction is working, and try to understand, like, not to enforce what you want to do, but try to understand what is the practice in international arbitration and what is the practice of the practitioners who are working in that jurisdiction. So summing up, I think there is no like A+ way to acquire cultural awareness for the purpose of international arbitration. But I am quite certain that once you get into this field, you will get to acquire the relevant or necessary tips for the cultural awareness. And at the same time, at the junior level or at the student level, I think it's efficient. It's efficient and it's sufficient that you get like there are many events or many networking events that you may attend for no requirements. So like just trying to show your attention, showing your interest would be the first step of raising your cultural awareness. Thank you very much.
Thank you for sharing your personal experience. And I think by keeping an open mind, trying to communicate, showing interest, the cultural awareness naturally comes to you. I think that's the point that you were trying to make. Thank you for that. And now turning to career-defining moments, Mr. Richardson, I understand you've handled hundreds of cases in your career. So looking back, was there a turning point or a case that particularly shaped your career?
Yeah, I'll start by saying I think every case has something to teach us, and you should pay attention to what arises in every case. And I'll use an example of a case I had a few years ago where we were the opposing party through every stage of the hearing. At every day, they would make new requests for documents. They said, well, we should have gotten these documents. And from our perspective, we felt, look, you should have known that you needed these documents 6 months ago. And these continuing step-by-step requests are unreasonable. And every day they would say, okay, the documents you gave us yesterday point to these other documents that we now need. And I, at one point in responding to them, said, okay, we're willing to give the documents they're asking for today to not make the tribunal have to deal with this complex issue. But if you give a mouse a cookie, and I thought everybody knew where that went, because there's a very famous book in the US, if you give a mouse a cookie, it'll ask for a glass of milk. And it leads through a progressive story of each step that you give the glass of milk, they want a napkin. That you give them the napkin, they want a pillow. I thought everybody knew this. It's so famous that this was a line in the movie Air Force One in the 1990s, I think, in the US. I thought everybody knew this, but I said, if you give a mouse a cookie, and everybody looked at me like, why in the hell is he suddenly talking about mice? What does this have to do with our case? So I learned you got to keep the language simple. And that's a recent lesson that I'm still learning case by case. But I think the biggest impact on me was not even an arbitration case, but a pro bono case I did when I was back in DC. We were representing one board and a charitable corporation that was established by Congress following the War of 1812 in order to provide for a charity to give support for the orphans of the soldiers during the War of 1812. So this is a very old corporation, and back in 1812, you could not have a corporation of named women. It was somewhat unthinkable that married women could even own property, much less be named in a corporation. But this organization was established by prominent women in DC. So to get Congress to create the corporation, they set up a named board of the husbands. And there was an unnamed board that was understood to be the wives, the women who actually would run the corporation, but the male board would have control over the money and the women would direct how the resources were utilized. Over the century and a half before I got involved in the case, it evolved to the successor to the male board was a group of very rich individuals, not from the community. The successor to the to the female board was people of lesser means from the community who ran the organization, actually ran the charity. And the male board decided, or the rich board decided, this is not efficient. We're just going to become a grant-giving foundation. We're going to kick the other board out. And we handled the appeal of the other board trying to say, you can't do that. And I learned from that case, you have to think strategically and creatively through cases, because we were working pro bono. We were not paid. The other board was paying their lawyer. And there's something in US court called a summary judgment, where you say to the court, okay, all of the factual issues essentially are no longer in dispute. You can decide this case as a matter of law. And we've reached that point. And we hadn't asked for, up to that point for money, but we had asked for an accounting because we wanted to know how they were spending the money. And I went to the partner managing the case and said, okay, but at equity in American law, an accounting in essence includes restitution. So why aren't we asking for restitution of the attorney's fees they paid for? And we made that request, and we got the order of restitution for the client, which was fantastic for them, and particularly for the poor board to get that money back into the corporation. Secondly, I got to argue the appeal in front of the DC Court of Appeals. And I went in as a fourth-year associate, arguing an appeal against a guy who was, he had to be 65 if he was a day. His father had served as a primary economic advisor in every Democratic presidential administration from Franklin Roosevelt to Bill Clinton. And he thought he was God's gift to corporate law in DC. And I was this young punk not even getting paid. But I did it. I handled it. It actually went really well. I realized halfway through that I had the bench on my side, because there was an argument about how by analogy, how the board of Brown University functions. And we said it functions exactly like we're saying this should function. The other side was saying, no, it doesn't. It's nothing like that. It's entirely different. And halfway through the other side's argument, one of the judges said, now be careful, counsel. I sat on the board of Brown University, and this sounds just like that. I realized at that point, okay, I have a friendly bench. I don't have to worry. But in that 25 or 30 minutes arguing the case, I felt like, okay, I'm home. And I realized, okay, this is what I want to do. This was the first big confirmation to me that, okay, I made the right decision career-wise. The other big thing was, particularly because this was a pro bono client for an indigent board of a company, we were doing something good. And we were doing good service for the community. And I realized that it actually feels good to see that what you're doing as a lawyer is not just doing the bidding of an affluent client that can pay you lots of money. You're actually providing service to the economy, to the market, to the society. And I realized that what we do as dispute lawyers is actually almost always serving a good purpose for society and for the community at large. Because even if you're paying cases for affluent clients, by creating a trust in the system of dispute resolution, you're creating trust in the economy, which allows parties to enter the economy, to do business, to create enterprises that create value, that give people jobs. So yes, we're not, as lawyers, we're not the most creative going out there, and I don't run SpaceX. I don't run a really creative business. But what we do does provide value to the economy and to society as a whole. And if what you do honestly and in good faith, I think that's an important part of what we do.
Thank you so much for sharing your experience. It was a very inspiring, passionate, and motivational war story for me. And I learned like what the purpose of a dispute lawyer could be, and it was very inspiring for me personally. Thank you. So my final question, I don't want to be my final question, but due to time, to all of you, is that if you were starting your career again in 2025, what would you do differently? What piece of advice would you give to your 20, 30-year-old self? Let's start with Ms. Njoroge, and Mr. Richardson in that order. Thank you.
Thank you, Misty. So this was the second difficult question when I was reading out your questions, and I thought about a while, like what would be what would be you may laugh, but the first thing is that I would have studied much harder in law school, because as I briefly mentioned in my previous presentation, Korean law is really important for you in actual practice as a Korean licensed attorney. But you know, as you keep your practice in international arbitration, you get less exposure to Korean law related issue. But once you get questioned, like you get a request from your partner or client on a Korean law issue, damn, I'm in trouble. Like then like you know, the disaster starts. So the first thing I would recommend is that in law school, like even if you want to become an international arbitration attorney, what you need to focus on is to study on the civil law. Like I don't think criminal law would be that relevant, but the civil law, like commercial law, or the civil procedure, civil procedural or enforcement related laws, those are really important, even if you pursue your career in international arbitration. So I would say that I would have studied harder so that I could become a better prepared practitioner. And secondly, I mentioned the networking. Do not be too stressed about networking, but I'm like I feel like I'm being a hypocrite. But like if I turn back to my early days, and I think I would have been more active in reaching out to seniors in this field to figure out like what it is actually like. I was very shy. Like I really hesitated to reach out from myself. So, but do not hesitate to reach out to your seniors elsewhere. Like for the participants, like for this event, like Jewel is the most renowned arbitration practitioner in the Korean arbitration community, and also the YAD. It's really difficult. It's a really precious opportunity for you to get to know a counsel working for ICSID. So like be active, be courageous, and reach out to them and ask like, hello, it was like good to meet you. Like I am this guy. Like be active, and do not hesitate to reaching out to the seniors that you seem to be your role model. So that would be the two advice that I could share in light of my past old days. Thank you very much.
Thank you so much, Ms. Njoroge.
Yeah, I very much resonate with what has said. And you know, when I wrote my notes, I said that I wouldn't change a thing, actually. I feel, in some respects, I feel so blessed to have had the rich background that I have had, coming from Nairobi, where I studied my entire life in Kenya. I'm qualified to practice law in Kenya, and to be practicing as an international arbitration practitioner as counsel at ICSID. I feel blessed. I feel blessed to have, you know, taken the steps that I did. In so many ways, I feel like every opportunity was serendipitous, that I actually was in the right room, met the right people, and they gave me my next opportunity. And if I were to change anything, I probably would have done a different skill. I would have probably done or studied French if I could go back to a gap year that I had in between high school and joining my undergrad. I had a whole gap year and I could have studied something else. I did accounting, but I don't know if it really helped me. Numbers, we see numbers and, most lawyers get a blank, but I probably would have studied a different language just to support my international view of things. I think that would be the only thing that I would change. And, just to go back to networking, I would probably, I used to have very many role models, famous people, maybe celebrities, I would say. I don't know if they're celebrities, but I had people in my life that I thought that if I met them, my life would change, if they only, paid attention to my email, once I emailed them like 10 times, 10, 20 times, if only they would give me my chance, But, after, a series of cold emails to people who I thought, would be my ladder, my step up ladder, I realized that the people that I already knew were the people that I needed, they were the ones that I needed to be networking with, the people that I knew in school, the people that I graduated with in law school, the people who we had a very hard life in law school together. I think those are the relationships that I would have valued more. And now in hindsight, they say hindsight is always 2020. I think some of the things that I did were very cringe, but I can say that they led me to where I am today, which is I feel very blessed. And I think everybody brings something to the table. And it may be your unique set of skills. It could be your language that you speak. It could be even the difference and the energy that you bring to a room. I feel like everybody has something that they bring and they offer. So you can hone that, you can package that, and people will remember you for that one thing, and they will hire you for that one thing. So that's all I have to say. And if this is my last speaking opportunity, I just want to wish everybody who is, in the cusp of a new opportunity, in the cusp of graduating, your master's, whatever, you just know that all you need is your next step. Like, you don't need to figure out your 10-year plan or your 5-year plan. I'm sure, Joel, the time you're moving to Korea, you just had your, your 2-year plan. You just needed to move to Korea. And for me, I also just needed to do a master's, go back home and do something. Like, all you need is just the next step. Once you figure that out, the rest will sort itself out. Okay, that's all.
Thank you. Now it's on to our last speaker, Mr. Richardson.
Well, I've given a warning not to use cultural references, but in answering this, I'm going to make two. I'm going to say that I've reached an age in life where I think a lot on Robert Frost's speaking about the road less traveled, and I think back through decisions I've made that were they the right decision at the time? How would my life be different if I had not made them? And I think of at university, I was a German minor until I decided I wanted an economics PhD, and I had to drop the German minor to get a math minor. And I wonder what would have happened if I continued to study the German. And then when I started as an economics PhD, I did part of a year of study of economics graduate school and decided the full 8 years to get a PhD was just going to take too long. So I got rid of the PhD program and focused on the law. And I think, how would my life be different if I had followed through on that PhD? And I think the lesson I've learned from those things is, A, opportunities past are not gone. I'm restudying German now. I don't know if I'm going to ever get to the level I would have been, but I have time to enjoy it and make fun with it. And I'm doing okay in my career with not the PhD in economics. And I've taken a different path, and I'm doing the best I can on that path. And I think pursuing your career, as Leah says, make the decision that's best for you at the time and move along that path, and don't let the decisions you've made hold you back. The other point I want to make is relating to Moneyball, the movie, which may or may not be familiar to people, but I talked about the three most important skills or biggest skills to have as an arbitrator. Now I'm going to talk about Moneyball, because I think part of the point of Moneyball was we can't replace this one player who has all the skills. We need to replace those skills in the aggregate. And I think building an arbitration team is somewhat the same, that not every member of your team is going to be the best writer or the best speaker or the best at networking. You need to have all of those skills somewhat, because you need to do all of those things. But focus one at a time on building skills. Don't neglect the others, but think for a time of, okay, I need to improve my writing, and do the things you need to do to improve your writing. Or think, I need to improve public speaking. I need to do the things I need to do. Don't get caught up in, I have to do all of these three things all at once. But do your career as it comes to you, and do it to the best that you can, and you will develop these skills. And don't focus too much on the picture of, I have to be the outstanding senior partner. I'm still hoping someday I'll get to that point of being the outstanding senior partner, but don't think you need to get there in one step. I think it's a process, and it'll take time. And I think you will get there if you keep on each stage doing the best you can at that stage.
Thank you very much, all three of you. I cannot believe we are out of time. An hour flies so quickly. And in the interest of time, I think it's time for us to wrap up. But I would like to extend my sincerest thanks to our amazing panelists for wholeheartedly sharing their personal stories, experience, and advice to our students and young practitioners in the crowd. I was moderating the session, but to me, I feel like I attended somewhat a master class for juniors. I've learned so much from all of you, and I'm certainly our audience would have felt the same way as I did. And thank you again to YIAA for organizing this amazing event and for making this session happen. So without further ado, this is all. Thank you.
Thank you, Miss Lee. Gratitude to Mr. Richardson, Miss Njoroge, Miss and our moderator, Miss Lee, for the vibrant discourse and insightful tips for the students and younger practitioners. I was so busy taking notes throughout the session that I almost forgot I had to host this webinar. Thank you again. And this now concludes today's webinar. The insights today have been both enriching and enlightening. I cannot thank our speakers enough for all they have shared today. As we end, please join me in extending a special appreciation to Soram Kim, Jihang Park, and Yeju Che, our team host committee that made this event possible. We also express our greatest gratitude to Professor Jungi Kim of Yonsei Law School for his unwavering support throughout this journey. Above all, we sincerely thank every one of you in the crowd for joining us today. You are YAD. We eagerly anticipate your presence again next year for YAD 2016. Until then, thank you and goodbye.
Bye. Thank you.
Thank you.
Bye.